So welcome to this session where we will explore what meaningful, effective remedies look like and also what an effective remedy or grievance mechanism needs to look like as well. To begin, it is important to acknowledge that access to effective remedies is not a side issue. It is a core pillar of responsible business conduct. In fact, one that is embedded in the UN Guiding Principles on Business and Human Rights, the OECD Guidelines on RBC, on Responsible Business Conduct, and the ILO's M&E Declaration. Yet far too many people affected by business-related human rights abuses effective remedies remain out of touch. In the Asia-Pacific, there are multiple avenues for addressing harm. National human rights institutions can investigate complaints and provide victims with legal support. OECD national contact points offer mediation for alleged breaches of the OECD guidelines. At the same time, regulators and investors are placing greater scrutiny on how businesses respond to human rights impacts. This has driven the emergence of operational level grievance mechanisms at company, industry, and even multi-stakeholder levels. But we must also recognize the inherent risks. Too often, these mechanisms can remain box-ticking exercises rather than pathways to real justice. And so this session, which is co-organized with the OECD Center for Responsible Business Conduct, will offer us an important opportunity to critically reflect on how different actors in this region can ensure that remedies are not just promised, but delivered, and that those remedies truly make a difference for victims. Joining me today, I have an esteemed panel of colleagues, Secretary General Hansa Homhuan, who is the Secretary General of the National Human Rights Commission of Thailand, Junya Tanaka, who is a Japanese creator artist and former member of a successful boys group called Johnny and Associates, now known as Smile Up. He survived repeated sexual abuse in his teens by its founder, late Johnny Kitagawa, and has since stepped forward to accuse the perpetrator. Also with Junya Tanaka is Kazuya Nakamura, who too is a survivor of sexual abuse involving Johnny and Associates. To my left, I have Kate Wilson, who leads the OECD Center for Responsible Business Conduct's work to promote responsible business conduct across the Asia-Pacific region. And then last but certainly not least, I have Fale Andrew-Lisa, who is a city councillor and a magistrate for the district court, specializing in grievance mechanisms for over 16 years. He is also a policy consultant at the Asian Development Bank and supports the work of the New Zealand Samoa Trade and Investment Commission. Indigenous to Samoa, he has a personal stake, as he says, in protecting Indigenous knowledge and businesses. And so please join me in a round of applause to welcome our speakers and thank them in advance for the insights that they will be sharing. And so with that, let me first turn to you, Tanaka-san. We understand, of course, that you have been through a lot as a victim survivor of sexual abuse and exploitation in Japan's media and entertainment industry. Can you please share with us the challenges that you've experienced as a victim survivor in accessing effective remedies and what you see as being the necessary path forward in order to ensure that victims, survivors such as yourself are assured justice? Please, the floor is yours.
はじめまして、田中純也と申します。日本から来ました。
Good afternoon. My name is Junya Tanaka from Japan.
今からお話しさせていただくこの問題は、日本のジャニーズ事務所の代表、ジャニー喜多川という人物から、私を含め1000人以上の子どもたちが性的虐待を受けたにもかかわらず、ジャニーズ事務所の大きな権力とメディアの沈黙の中で何十年ももみ消されてきたこと、人類史上最悪の性犯罪が日本で何十年も起こっていたこと、そして現在、日本では何が起きているのかを皆様にお話しさせていただきます。
The issue I'm going to share today is one that has been silenced for decades, suppressed by the overwhelming power of Japan's biggest talent agency, Johnny and Associates, and reinforced by the media's silence. It concerns sexual abuse suffered by over 1,000 children, including myself, by Johnny Kitagawa, the head of the agency. This constitutes one of the gravest sexual crimes in human history, allowed to persist in Japan for decades. I stand here before you today to ensure that people across the world learn about the truth, what happened, and what is currently happening in Japan.
私は1995年にジャニーズ事務所に入りました。その傍らで繰り返しジャニー喜多川に性的虐待を受けました。当時私はまだ14歳でした。被害に苦しみ、自殺を試みたこともあります。
I joined Johnny and Associates in 1995. During that time, I was repeatedly sexually abused by Johnny Kitagawa. I was only 14 years old. The suffering was so great that I attempted to take on my life.
私たちは合宿所と呼ばれる子供たちがたくさんいる部屋で寝ているときに一人ずつ順番にジャニー喜多川に襲われるのです。時にはみんなの前で一人でこっちへ来なさいとバスルームに呼ばれ性的暴行を受けたり、テレビゲームをしているのにいきなりアダルトビデオをつけられ、これを見なさいとそのまま性的虐待を受けた子供たちもいました。私が知っている限り、ジャニー喜多川による性的虐待のその多くは10歳から17歳ぐらいです。
My peers and I were victimized in various situations. For instance, in a dormitory called the training camp, where many children stayed, Johnny Kitagawa would assault us one by one in our sleep. Sometimes he would call one of us into the bathroom in front of everyone, saying, "You come here alone," and sexually assault us. Other children were forced to watch adult videos while playing video games, as he would suddenly turn one on and say, "Watch this," before sexually abusing them. As far as I know, most of Johnny Kitagawa's sexual abuse victims were between 10 and 70 years old.
しかし、ほとんどの子供たちは親へ話すことができなかったのです。それは自分が何か悪いことをしたかのような罪悪感や恥ずかしさ、そして何より親が知れば悲しんでしまうという子供ながらに思う親への愛情から来るものでした。
However, most of the children would not tell their parents. This was due to a sense of guilt and shame, as if they had done something wrong. Most importantly, it stemmed from a child's love for their parents, not wanting to cause them pain by revealing the truth.
私たちはスタッフに相談したりもしました。しかし、被害を知っているにもかかわらず、大人たちは見て見ぬふりをし、誰も助けてはくれませんでした。それどころか、隠蔽しようとさえしました。ジャニーズ事務所と日本のメディアたちは、苦しんでいる子供たちより経済的利益を優先してきたのです。
They spoke about the abuse about the studios where adults were present, and they consulted with managers and staff at the time. The adults knew about the abuse but turned a blind eye, doing nothing to protect us. In fact, they even tried to cover it up. Johnny and Associates and the Japanese media prioritized their economic interest over the suffering children.
それから25年以上が経って、ようやく私は勇気を出し、声を上げることができました。しかし、被害を訴えることは極めて難しい状況にありました。それはジャニーズ事務所が性的虐待などないとずっと否定し続け、虐待にあった子供たちが被害を訴えられない、そんな状況を作り出してきたのです。
It took me more than 25 years to finally find the courage to speak out. It was extremely difficult to come forward. This is because the agency consistently denied the existence of any sexual abuse, creating an environment where children were silenced.
さらに被害を受けた子供たちが大人になり、もし声を上げようとしたとしても、日本には性犯罪の短すぎる時効という壁が立ちはだかっています。これにより、被害者たちは何もできずに、ただただ苦しむだけなのです。
Even when the victims, by then adults, tried to raise their voices, they were confronted with a barrier of Japan's short statute of limitations for sex crimes. As a result, victims were left powerless and forced to endure ongoing suffering.
そんな中、2年前、イギリスの BBC がこの事件を報道してくれたことをきっかけに、日本中がこの事実を知り、ジャニーズ事務所は子供たちへの性的虐待を認めることとなり、社名をスマイルアップへと改名しました。
Amidst these circumstances, 2 years ago, the BBC reported on this long-hidden scandal, finally bringing the truth to light across Japan. As a result, Johnny and Associates finally admitted to the sexual abuse of children and changed its name to Smile Up.
その後、その改名したスマイルアップ社が、救済などという名のもとに、保証額さえどういう算定根拠に基づくものなのか、具体的な説明もない謎だらけの枠組みの中で、勝手に決められた保証額を被害者に渡し、もしこれに合意せずに従わない者には訴えを起こし、苦しんできた被害者を被告にし、社会的に叩き潰すという権力の乱用がまた始まりました。保証基準の具体的な説明がないということや、対応の仕方からも極めて不誠実な対応だと思います。どのような基準で救済の内容を判断しているのかが事前に分かれば、被害者にとっても保証金額が妥当かどうかを理解し、納得できる協議ができると思います。
Subsequently, under the guise of relief, this rebranded company, Smile Up, began abusing its power. It offered decided compensation amounts to victims who were constrained by the statutes of limitations, without carefully hearing their voices. The process was carried out, done within an opaque black box framework called the Victim Relief Committee, with no concrete explanation of the basis for calculating the compensation amounts. If a victim does not agree to their terms, Smile Up files a lawsuit against them, turning the victims who had already suffered so much into a defendant in a courtroom and attempting to crush them socially. I believe their handling of this extremely insincere, as the compensation standards do not seems to be based on what happened to each individual, and there is no specific explanation for the calculation table behind their offer. If the criteria used to determine the content of the remedies were made clear in advance, victims would be able to better understand whether the compensation amount is appropriate and engage in a more informed and satisfactory discussion.
そして現在、日本ではスマイルアップ社が被害者を訴えるという裁判が相次いでいます。現に私も旧ジャニーズ事務所から名前を変えた2つの会社、スマイルアップ社とスタートエンターテインメント社2社から訴えられています。
Currently in Japan, there is a succession of lawsuits where Smile Up is suing the victims. In fact, I am being sued by 2 companies that were formerly Johnny's and Associates, Smile Up and Start Entertainment.
なぜ被害を受けた人が加害者側から訴えられなくてはならないのでしょうか。弁護士費用や裁判費用、心の負担、加害者たちはさらに何重もの苦しみを強いられています。スマイルアップ社が本当に被害者のことに気にかけているのなら、被害者を相手に訴訟を起こすようなことはないはずです。
Why should victims be sued by the perpetrators? Victims are now forced to endure multiple layers of suffering, including heavy legal expenses and immense emotional distress. If Smile Up truly cared about the victims, they would not be filing lawsuits against them. I cannot help but feel that their gestures of consideration for victims are a sham.
私は当時、ジャニー喜多川に連れられ、海外にも行きました。私が15歳の時です。雑誌の撮影で訪れたアメリカ・ネバダ州ラスベガスの一室で、ジャニー喜多川から性的暴行を受けました。その後、ロサンゼルスやグアム、ハワイでも被害に遭い続けました。
Johnny Kitagawa took me on overseas trips when I was 15 years old. I was sexually assaulted by him in a room in Los Angeles, Nevada, during a magazine photo shoot. I continued to be abused in Los Angeles, Guam, and Hawaii, where he took me afterward.
そのため私は昨年12月、自分が被害を受けたアメリカのネバダ州で、旧ジャニーズ側に訴訟を提起しました。なぜかというと、ネバダ州には時効がなく、日本にはないディスカバリー制度というものがあり、これによって今まで日本では公開されてこなかった隠された情報が表に出てくる可能性があるからです。彼らが何を隠していて、当時子供であった被害者を守るために何をしてこなかったのか、こういうことを明らかにしたいからです。
For this reason, last December, I filed a lawsuit against the former Johnny and Associates in Nevada, the state where I was victimized. I did this because Nevada had no statute of limitations applicable to such sexual abuse, and it was a discovery process that does not exist in Japan. This system could potentially bring to light the covered information that has been concealed in Japan until now. I want to clarify that they have been hiding what they did and what they failed to do to protect the children who were victims at the time.
今、日本ではこの性加害問題がすでに終わったかのように見せ、メディアやスポンサーは何事もなかったかのように旧ジャニーズの番組起用を増やしています。この問題は決して終わっていません。私たちは被害がなかった人生には二度と戻れないのです。
Right now in Japan, it seems as though the Johnny's sexual abuse scandal is already over. The Japanese media and sponsors are increasing the use of male idols or celebrities belonging to the former Johnny's and Associates in their programs, as if nothing ever happened. This issue is far from over. We can never go back to the lives we would have had if we had not been victimized.
重要なことは、旧ジャニーズの問題において、何が起こったのかをみんなが知る必要があると思います。そして、被害を止められたかもしれない人たちが、見て見ぬふりをして、何もしてこなかったと、そういう過ちをみんなが認めることです。望んでいるのは、子供たちの人権が守られ、しっかりと保護される仕組みが作られることです。
What is crucial is for everyone to know what happened in the former Johnny's case, and for those who might have been able to stop the abuse to admit their wrongdoing, that they looked the other way and did nothing. What I hope for this is the creation of a system that protects children's human rights and ensures they are properly safeguarded.
そのためには、今回の組織的な性犯罪について、個人の責任の追及にとどまらない、問題の構造を明らかにするために、徹底した事実調査をするための仕組みが必要です。これ以上、同じ思いで苦しんでいる子供たちがいなくなるよう、そして、いつかこの問題を通して、日本の遅れている法制度や人権意識を変えていくきっかけになれればと思います。
To that end, I firmly believe that it is essential to create a mechanism that enables a thorough fact-finding investigation into the present large-scale and organized sexual crimes, not limited to pursuing the responsibility of individuals, but aimed at revealing the structural problems underlying the matter. I sincerely hope that no more children will have to suffer like me, and that one day this issue will become a catalyst for changing Japan's backward legal system and awareness of human rights.
皆様、本日はどうもありがとうございました。
I am truly thankful for the opportunity to speak before you today. Thank you so much for your kind attention.
Thank you so much for your courageous sharing of your experiences, and also for sharing with us what the road ahead needs to look like in order to ensure that the children of Japan, but also victim survivors in this case, are properly ensured access to justice and access to effective remedies. With that in mind, Let me now turn to Secretary General Hom Hwan from the National Thai Human Rights Commission. Your commission will have received, I'm sure, many complaints related to business activities. Would you be able to please share some observations based on the complaints that you've handled in relation to how effective remedies can be assured, what kind of challenges victims may face or rights holders may face in accessing effective remedies, but also, if I may add just one more, what can businesses do to ensure that they have effective grievance mechanisms? Over to you. Thank you.
Thank you very much, Dr. Pishamun, and thank you for giving me the opportunity to address this session. We, National Human Rights Institution, we are state-based non-judicial grievance mechanism, and of course one of our most important functions is to receive complaints on human rights violations, not only by state agencies but also by private businesses. We have received quite a few complaints on violations or abuses by businesses, but I would like to give some example of some cases that we have successfully intervened and resulted in effective remedies. The first case that I would like to mention is about a complaint by Bangkok residents who have been affected by a large construction project in their community. The construction has caused flooding, blocked access to their homes, and even damage to their houses. And by the law, the company was required to report every 6 months on how it was implementing mitigation and preventive measures from the construction project. But the main reason behind the continuing complaints was the lack of proper communication between the community members and the construction project. The community members, they complain to us because they cannot access, they do not have any channel to access construction project managers to voice their grievances. And so we stepped in and we brought all the key actors together, the company, the engineers, local officials, and community members. And through this dialogue, everyone was able to share information and build understanding, which led to the agreement on what corrective measures were needed, as well as who would take responsibility for each action. And as a result of the meeting and the dialogue that we have recommended, the National Human Rights Commission has proposed some remedial measures to both the state agencies concerned and to the companies. For the state agencies concerned, we propose that they should be more vigilant in supervising the construction to not to cause problems to residents nearby. And for the company, we propose that they repair all the damaged roads and houses caused by the construction and fix the problems with transportation routes and drainage systems to ensure safe access and reduce flooding, which is quite a serious problem for Bangkok residents in general. And thirdly, we also ask them to adopt preventive and corrective measures that are practical and make sure that such measures will respond to the real needs of the community. And most importantly, we propose that the company improve communication with the community by setting up a 24-hour hotline and publicizing these communication channels to the residents so that when they have grievances, they know where they can voice their concern. And at the same time that they should maintain the existing line group with active participation of the staff of the construction project so that they know what the problems are and update the community of what corrective actions that they will take. So from this case, I think the challenge, first of all, is the lack of trust, I think, between between the residents and the construction project. They don't seem like they cannot come together and have a discussion to really know what the problems of the project and how to solve it. So I think with the intervention of the National Human Rights Commission, I think what's important about this process is that we are an impartial body, and I think it creates a sense of trust between the parties that we would do our duty based on human rights principles. And with that, I think it has led to the solution of the problem, and also lead to the company to adopt preventive measures, give a confidence to the residents that these problems will not reoccur. And at the same time, it has helped build back the sense of the need for both sides to live together and not in conflict but in cooperation. So I think this is the lesson that we have learned. I think if there's some challenges, I think it's for all of us, for the National Human Rights Commission, that we have to do our duty well. We have to make sure that both sides trust in our performance of duty, and both sides also have to open their mind and listen to the other party, their perspective of the problem. And when there is a sense of trust, I think that has led the dialogue to go on and lead to a successful solution. So I think we also, this case also led to the company establishing a grievance, operational level grievance, to communicate with community nearby whenever their project has caused some problems with residents in the area. So this is one thing that we think would help lessen the conflicts that will arise from this construction project, because communication is key to solving problems, but also, of course, the intention of both sides to try to find an agreement, because they have to live together. They cannot move away from each other. So I think this is one case that I would like to give as an example of how we find solution on violations by businesses. Thank you.
Thank you very much, Secretary General Hansa, for sharing that example, and also for helping to not only underscore the important role that national human rights institutions play in ensuring access to justice and remedy, but also helping to underscore the importance of trust when it comes to remediation processes. So mulling over that point, I would like now to turn to Kate. Kate, you, of course, in your work with the OECD, have plenty of experiences also engaging with national contact points. In addition to perhaps briefly telling us more about what these national contact points are under the OECD guidelines, it would be great if you can also please share some examples of remedy outcomes that NCPs have been able to achieve in relation to cases that we see in this region. So the floor is now yours.
Thank you very much, and thank you very much for having me here at the forum. So for those of you who don't know about national contact points for responsible business conduct, I'll quickly explain what they are. There are 52 of these around the world. They're often referred to as NCPs, and they're agencies housed in governments that have signed up to the OECD guidelines for multinational enterprises on responsible business conduct. So these guidelines cover all aspects of responsible business conduct, including human rights. They're a non-judicial grievance mechanism, and they receive complaints from individuals or organizations who allege that a company has breached the OECD guidelines in their operations or supply chains. So Across the 52 around the world, over the past 25 years, they've received 700 complaints alleging breaches of the guidelines. So we now have quite a database of examples of the sorts of things that are raised. These are transnational in nature, the cases, because an NCP can receive a complaint about activities of a company operating in or from a country that adheres to the guidelines, so has an NCP. So many of these have been in the Asia-Pacific region. Around 25% of those 700 complaints have come from activities in the region. Each NCP is structured a little differently, but there are standard criteria and standard steps that they need to fulfill. For example, once a complaint's accepted, an NCP will offer mediation between the parties to resolve the issues that have been raised. But if the complaint can't be resolved through mediation and the parties don't agree to enter into that step, it goes to an examination stage where an NCP looks at the issue and produces a public statement where they may determine whether or not there has been a breach of the guidelines. They may also make recommendations to the company on how they can address the gaps or remediate the harm that's been caused. So to give you an indication, NCPs have received complaints about topics such as or issues such as hydropower dam projects in Sarawak in Malaysia, banking services provided to fund sugar production in Cambodia, and the activities of companies in the mining and extractive sectors across a range of countries. This is, as we know, one of the higher risk sectors, so we see a number of NCP complaints in relation to extractives. Many of the issues raised, if we look across the 700 cases, are also on labour rights. It's a very common issue that comes up in manufacturing segments of supply chains. And there are also examples, cases that focus on environmental harm and the rights of the communities affected by these developments. So the sorts of remedy outcomes that we've seen from these processes, generally speaking, they've taken the form of apologies, changes in policies and practices to halt the harm or avoid it in the future, or new systems or structures that enhance engagement between the company and the complainants or the community involved. In some cases, we've also seen financial compensation. And further examples still, which I think are interesting to note, that there have been agreements made between the parties to a complaint at an NCP to conduct studies on the impacts of the people and environment of the particular site or the particular investment as an important way forward to establish what needs to be done. So we've also seen in some cases that operations have indeed been halted because of an NCP complaint. That's not always what's being sought, and that's not a common outcome, but we have seen it. And it's probably worth saying that a lot of these outcomes, the NCP process is not necessarily like an emergency avenue for communities or people to take. It's more of a lot of the outcomes are long-term improvements or those sorts of and long-term mediation between the parties. So not necessarily a immediately halting a situation. But the remedy, and I really think it's worth noting the improved stakeholder dialogue outcomes that we have seen also. So there have been relationships built and trust built between the parties to NCP complaints, which have expanded beyond beyond the lifetime of a particular complaint, and structures being set up where that engagement can continue. So NCP cases can be a catalyst for more genuine stakeholder engagement, which I think is key. So some of these remedies are forward-looking and about improvements, changes to policies, setting up of grievance mechanisms at the company level or the operational level where they didn't already exist. So trying to prevent harms in the future, and then others have been about redressing those harms that have occurred through compensation, apologies, and redress. So we see that's the sort of range of outcomes we've seen. Everyone gets it.
I tend to get so excited with asking the next question that I forget that I should properly thank the speaker, in this case, Kate, for providing us with insights into how NCPs work, but also some very concrete outcomes indeed from the NCP process that, from the sounds of it, has actually resulted in better outcomes for the rights holders and the businesses involved. So with that, let me turn to you, Andrew. And where do I start? You have so many hats. So let's see if I can pick a couple for you to speak from. Given that you work with the ADB and also with the New Zealand Samoa Trade and Investment Commission, and at the same time you are also an Indigenous person yourself, can you share with us the challenges that rights holders, including Indigenous peoples, face when it comes to accessing justice and remedy? But perhaps from your investor perspective, what do you see as being steps that can be taken by investors, by businesses, to ensure that there is, in fact, effective remedies and effective grievance mechanisms underpinning them? Over to you.
Thank you. No pressure. I think that's the hardest question of the panel today. Warm Pacific greetings, distinguished guests, ladies and gentlemen. I want to start by painting a picture, because for Indigenous communities, there is some historical grievances around the remedial and judicial processes. They haven't always worked for our community. There's been a culture of failure in terms of providing remedial and judicial processes that work for our people. They often come with a Western lens, for example, and they're not always culturally appropriate. In New Zealand, for example, you go as an individual, but in the Indigenous setting, justice is communal. You go with the collective, you go with members of your family, you go with elders, you go with religious leaders. Justice is communal, it's collective, it's about the community. And in remedial processes, particularly in the Western world, the opposite is true. There's confidentiality processes, and so you can't speak about the case with members of your family or with your friends or colleagues, because then you would be in breach of confidentiality. So that cultural dilemma, if you like, is a barrier, not only for Indigenous communities, but for migrant workers, for women, for people with disabilities. Access requires cultural sensitivity, and when you're not culturally aware, when you're not culturally sensitive to those differences, justice can look very different. And so I guess from my perspective at least, there needs to be a genuine effort to engage in marginalized communities so that those remedial processes are open and transparent, that they engage with the underrepresented communities the most, because unfortunately those are generally the communities that have failed the most by these remedial processes. And so the key is to identify the barriers to access. There is a lot of distrust in the Indigenous community in particular. We don't always get a fair hearing. We feel like access to evidence is probably critical, and often businesses don't play ball. They don't allow you to access the evidence that you need to build your case in a remedial process. And so that is a key barrier in terms of getting a fair hearing. Natural justice without the right to information obviously can't exist. And so businesses need to play ball by making sure that you have access to all the evidential statements and, all the evidence that you require to build your case. They shouldn't be able to threaten you with termination, which is often the case. And so the fear of engaging in that process, because you may lose your livelihood, you may lose your salary, and you're a provider for your family, for your community. So, that fear is probably one of the biggest barriers as well. How do we improve those reassurance mechanisms so that people feel safe to complain about their employers and companies, and they don't feel like they will be targeted as a result of that as well? And so I guess for me, the best practice here is a system or a process that is A, culturally appropriate and culturally sensitive, B, open and transparent, C, inclusive as well to all the diversities we talked about, earlier, and D as well, it's about the cost to some of these remedial processes, having to pay for lawyers. Even labor unions haven't always been Indigenous friendly. So some of the stakeholders in the process are not always inclusive or supportive of minority groups such as Indigenous communities. And that has been the experience on the ground for many. And then finally, I also think it's about having Indigenous people on the other side of the remedial process. And so I talked earlier about being a judicial officer in New Zealand. And so my role is to work directly with Indigenous communities so that they see themselves in the process. If minorities don't see themselves reflected in a remedial process, they won't have faith that this is a fair, that this is a genuine process. So by having diversity in the remedial process administration, I think that's fundamental to building trust in those minority communities as well. And I think I've covered most things, but from the Indigenous context, it really is about having businesses being proactive and building resilience rather than being reactive and only responding when there are cases. How do you make the workplace safer for everyone, more supportive? Because, for Indigenous people, when we go to work, it's like we're going to our second family. We see colleagues as members of our extended families. And when we are let down by businesses, by our employers, that's a personal experience for us. So investing in mental well-being when you're at work, for example, is fundamental to Indigenous communities, to everyone really. Everyone wants to feel safe and supported at work, and everyone has a right to do that. So I encourage businesses, companies and employers to invest in people, because people are your single greatest commodity. Well, commodity is probably the wrong word there. That's my ADB hat there. People are the single biggest asset to any company or business. That's my city councillor hat. And we'll leave it there.
Oh, Andrew. Thank you very much for that intervention. I think you've identified, a key issue there about barriers to access to remedy, which really centers on the need for more intersectional approaches for businesses in particular to include intersectional considerations into the design of grievance mechanisms and of the remedies that should also be consulted, should be arrived at in consultation with those affected. So we have approximately 15 minutes or so to take questions from the floor. So let me open it up now to see whether anyone would like to ask questions to our speakers or to individual speakers. If so, then please indicate this. The floor is open. Yes, please, colleague in front.
Hello. Hi, I have a question for Mr. Tanaka. Beyond providing transparent remedies and refraining from retaliatory lawsuits, are there other ways in which companies can fulfill their responsibilities?
Eh, 被害者を誹謗中傷から保護するメカニズムが必要だと思います。今、被害者が心のない誹謗中傷などの二次被害に遭う状況が続いています。その場合には、加害企業において法的対応や、その費用のサポートが用意されていることを約束してもらえたら、とても安心できると思います。
There also needs to be a mechanism to protect victims from slander and defamation. At present, victims continue to face secondary harm through heartless attacks and defamation. In such cases, it would provide reassurance if the responsible company committed to covering legal support and other necessary costs.
Thank you very much. Yes, please.
Hi, thank you. I'm Neila. I'm working for Manushaya Foundation. I have a question for Kun Hansa and Kate. Do you know whether Thailand has been working on developing an NCP as part of the accession process? And if so, has the NHRCT been involved? And also, can you please make sure that civil society will be involved in the development of the NCP? Thank you.
Thank you for that question. Secretary General, would you like to go first?
Yes, we know that the Thai government is in the process of becoming member or observer, I'm not sure, of the OECD, and there have been discussions about who will act as an NCP. For Thailand, for the National Human Rights of Thailand, we haven't been approached officially by the government. We have to learn more about the role of the NCP so that we make sure that if we are assigned this role, we will deliver the mandate effectively. We, of course, we have the mandate to receive complaints, and we can continue to receive complaints even though we are not NCP, and we will do our duty. And if there's anything that we can coordinate with the NCP, if it's established in Thailand, we would be happy to do so. Because at the moment, when we receive complaints, we made recommendations to concerned authorities, but our recommendations do not have enforcement power. So if there's an NCP, whether it's the NHRCT or some other agencies, if the NCP can make sure that the problems can be solved, if it would give more strength to our recommendations in trying to solve the problems, then we would be very happy and to cooperate with NCP and other concerned agencies. Thank you.
And to add to that, so at the moment, the stage that the Thailand's accession to the OECD process is at is before the initial memorandum. So at this point in time, the government of Thailand is preparing its self-assessment initial memorandum, which it will submit to the OECD in the coming, I think the time frame is at some point in 2025. I'm not sure if it's changed at all, but it's still underway. And so after that point, more work will happen between the institutions. So it's too early in the process still to know what the government of Thailand will do in relation to its NCP. But we do see all around the network of NCPs a lot of engagement with NHRIs. So they have very common interests, and working with the NHRIs and NCPs is a positive thing in many of the adherent countries.
Thank you, Kate. Yes, over there. Please go ahead.
Yes, good afternoon. I just want to ask particularly on the OECD, because the NCPs do not have the same interpretation of the free, prior, and informed consent. And some are good in interpreting it, some are not bad. So we've been using that, and we have good results on those that understand it better and not on the other one. So we want to know if there's any plan to actually develop a guideline for NCP so that there's a common understanding on how they will interpret and apply FPIC. And we've extended our cooperation to do that. Thank you.
Before you take that question, Kate, let me take another question from the floor. Yes, please.
Yeah, I am Zubair Torwali from Swat, Pakistan. My question might be answered by Andrew or maybe another panelist. It has been more than a year we are engaged with the GRS of World Bank. World Bank funds 2 mega hydropower projects in that particular area, and we are very indigenous to that land. And now World Bank is trying to push us back to the government, against which we have approached the bank. So I am curious what to do next.
Yes, please. In the interest of time, I will take those two questions over there, please.
I just wanted, my name is Praveen, I'm with the Asia Indigenous Peoples Network on Extractive Industries and Energy. I just wanted to build on what Zubair has said, and with regards to grievance mechanisms of multilateral development banks, particularly project level grievance mechanisms, that we see that these mechanisms have not been effective, and it's also a similar experience with national contact points of the OECD. Unfortunately, I myself have been involved in supporting communities file complaints with the US NCP against Marriott International and the Swiss NCP against Visa Facilitation Services Global. Given that these are non-judicial mechanisms and they have very limited dispute resolution mandate, these NCPs, the remedy that the communities that they can get or they can seek is limited in the first place. And even when there is some dialogue or dispute resolution, the enforcement is absolutely missing. So I think, my question in that regards would be to Kate: is there any movement, is there any discourse that these OECD national contact points need to be provided more powers so that there can be more effective remedial mechanisms for communities?
Yes, in very much the same vein, but also going a little bit, Junia's experience and looking at sort of how it goes across the entire chain. So right down from local governments, I'm from Pakistan, also where Zubair is from, working closely on those same projects, World Bank, ADB, and then also intermediary lendings. And so you might have local levels or dispute resolutions in the shape of, for instance, ombudsmen and so on. But again, the approach to grievance redressal seems to be a matter of dispute resolution. I think there's a focus on that side of the equation. The restitution is missing. The capacity to actually deliver the funds that are necessary for that is missing. And since in the case of multilaterals, we have an open question now, which is how far are they subject to the UN's laws independently, independent of their alliances with local implementing agencies, independent of the laws that the lending countries that they lend to have. So the question really out there, and we want to get a perspective from all of you, what do you think the UN needs to do to ensure that other multilaterals who do not have the same kind of checks at national levels, what can we do to ensure that they fall under the fray of the UNGP and other things?
Okay, thank you for those questions. I think colleagues on my left-hand side, Kate and Andrew, perhaps you can tackle some of them. And I think also there's a bigger question here about what can the UN do, and perhaps the working group as well. I'll put myself in the mix there to ensure that effective remedies are provided to victims, to rights holders, and perhaps Junya-san, Secretary General, you might also want to weigh in on that. But for the moment, let me turn to you, Kate.
Thank you. Yes, I'll briefly answer two of those questions. Thank you very much for your question on free, prior and informed consent. The short answer is there's no plans underway for specific guidance on that topic, but there's certainly a lot of, we know that across the network that's something that is raised in many of the complaints. That is a relevant issue, and I know there have been there's been some work underway at the OECD to facilitate engagement between Indigenous groups and NCPs, and using the OECD forum and working with organisations to do that. But it would be good to speak after the session about your experience. And then on the strength of NCPs. So there's a couple of avenues or methods that the OECD uses to try and enhance the capacity of NCPs. One is the peer review process, so they undergo peer reviews. The other is bringing together and sharing across the network frequently with each other, so that there's functional equivalence between the different NCPs, and they're all lifted up to a high standard. And the other thing I will mention, in the 2023 update to the OECD guidelines, there was a change in there around follow-up statements. So there is now an expectation that NCPs publish follow-up statements to complaints. So that's an important step in the process in terms of seeing what has and publicly publishing what has happened since the closure of a complaint. But happy to speak after the session.
Responding to the question on multilateral banks, unfortunately, multilateralism in general is actually fading out of fashion. And you'll notice all over Europe and the United States, Asia, populism is on the rise. And what that means is that countries are contributing less to these multilateral agencies like the Asian Development Bank, which happens to be a subsidiary of the World Bank. And so I don't want to speak for the World Bank because that would be implied, but I do want to say that we have less than we've had previously and we're having to downsize. And so that means that you may have been funded in the past, but now we're consolidating and we're trying to avoid duplication. We don't want to fund the same thing 1,000 times if we only have to fund it once. And so we're funding bigger projects. And so unfortunately what that means for smaller NGOs and smaller projects on the ground that are actually making a tangible difference, the banks may decide that actually there's something bigger that we can fund elsewhere that has a bigger impact on a wider audience. And so I do wish I had some reassurance for you, but these are very dark times and money is tighter than it's ever been, even in the UN, than it's ever been before. There are staffing cuts at all major banks, all multilateral banks, office closures. It's a very depressing time to be a banker in the multilateral space. And so I wish I had more news for you, but that's as good as it's going to get, I'm afraid. And my advice to you would be, if they're pushing you towards the government, also take advantage of the private sector and their corporate social responsibility mechanisms. I know that doesn't sound very exciting, and you have to jump through hoops just to qualify for that as well, but spread your eggs. Don't rely on one or two donors. Try to get as many donors as you can, because that's what builds resilience in your organization.
Thank you. That was thoroughly depressing. Speaking as part of special procedures, we are independent experts, but resources are indeed extremely low. And this is putting pressures on so many aspects of the work that we do, but also in contributing to ensuring that there is access to justice and remedy. All of that is much harder in the world that we live in now. Now, Secretary General Hansel, would you like to come in and share?
Yes, for me, I think as Thai people, I think they would prefer to use local grievance mechanism because it's they are more familiar with, and of course with the language and all that. We are not English speaking country, so it's sometimes very hard to try to complain in English. I think what's important is that we, National Human Rights Institution, we try to be perceived as an independent and capable mechanism that can help them with their problems. We have accreditation status. Every 5 years, we have to enter into this accreditation status by the UN to ensure that we are impartial, independent, and effective. But of course, UN grievance mechanism provide an alternative in case people think they cannot rely on national mechanism, whether it's state-based or non-state-based. So I think UN mechanism is still necessary, but honestly, I think UN mechanism is quite not easy to access, and it's quite a complicated system. So if the UN provide more friendly a mechanism for users, I think people would have more alternative. Yes, thank you.
Thank you very much for that. And then, can I check? Junya-san, would you like to say something as well?
その被害やその何があったかを明確にした上で、再発防止を外企業がちゃんとやるように、皆様からも提言をしていただきたいなと思っています。
When any human rights violations occur, we want the UN to make sure and make more effort to clarify the full picture and ensure that the offending company take full measures to prevent the recurrence. That's what we recommend.
Well, thank you very much. Because we did start a little bit late, I would ask for your forbearance in staying with us for just a few more minutes, because what I'd like to do is to ask our speakers to perhaps provide one key takeaway in perhaps 1 to 2 sentences max that you would like to Andrew just said, "Oh God," just in case you were wondering what he was doing. But one key takeaway, one piece of advice that you would like to provide to businesses in order for them to do remedy better, but also for them to have more effective grievance mechanisms. So, Kate, please.
I have a request of businesses that have gone through a process, a grievance process, maybe an NCP process or something else, to speak publicly and with your peers about that and how it helped. I think there are a lot of situations where it has actually helped companies improve their operations, improve their relationships with stakeholders, but we don't often hear of these stories. And I think if we did hear of them more, companies would be less fearful of grievance processes, and we really need companies to choose to engage in order to achieve real remedy. So I would encourage companies to share and talk about their experiences, stakeholder engagement of any kind, but particularly through grievance mechanisms.
Thank you, Kate. So communication matters a whole lot here. Secretary General, would you like to share as well?
Yes, I would like to suggest to businesses that you shouldn't view grievance mechanism as from a negative point of view, because it actually allows you to know in advance what problem is going to happen, and you can take preventive action before it can go so far and very hard to address. Thank you.
Thank you very much. Andrew?
One question that I always go back to in the remedial process is justice delayed is justice denied. And what that means is that we as employers, as companies, need to make sure that they are time bound, because what often happens is they are dragged out on purpose, deliberately by employers, so that people lose interest in the process and give up. And that's exactly the intention. And so by having a time-bound process, that's how you ensure genuine justice. There needs to be some kind of commitment from the employer that this is going to happen quickly, effectively, and it's going to be genuine and comprehensive, but that we can't drag this on for years and years or months and months at a cost to those who are going through the process, because they need to know, in terms of certainty, in terms of closure, they need to know as quickly as possible so they can get on with their lives. We can't have this dragging on for months and years with no end in sight. And we'll leave it there.
Thank you, Andrew. And then finally, Junya-san.
その加害企業には、話し合いの前に被害者が必要に応じて独立した弁護士に相談できることや、またその際の費用は加害者企業に負担していただけることなど、その費用面でのサポートをご検討していただけると、より安心して加害企業の保証枠組みに参加できるとは思うんですよね。はい。
So before the remediation process starts, we want the companies to make sure that the victims have the access to independent lawyers, and that the company support the full cost of the process, and so that the victims can access the remedy without any personal costs.
Thank you very much. And I would add to that as well that victims need to be able to access remedy without any fear of reprisals or retaliation. I think we've had a very rich discussion on this session, and thank you again for the questions and comments from the floor. Already, I think we have some key points to draw upon. Identifying barriers to access is an important departure point. Consulting those affected and designing grievance mechanisms and effective remedies is absolutely pivotal. Ensuring that trust, including by being sensitive to intersectional considerations of rights holders and victims, is absolutely critical as well. And then finally, I think we have heard here how it really is devastating when states and when businesses turn a blind eye to human rights abuses. The impacts aren't just to the individual, it can be to entire communities, if not society at large. And so today we've discussed emerging practices and observations that are very practical in nature. And I believe now's the time for us to ensure collectively that Pillar 3 of the UN Guiding Principles on Business and Human Rights on access to remedy will no longer be the pillar that is left behind. With that, please join me in thanking our speakers today and also our interpreters from Human Rights Now. With that, I bring this session to a close. Thank you very much again.